Welcome to this edition of Elder Care Answers. Elder Care Answers provides valuable information for senior citizens and those who love them so we can all be more informed consumers.
Hello and welcome to Elder Care Answers, a show dedicated to finding the answers to our elder care and estate planning questions. I'm your host, Mary Ravazio, and joining me are Michael Smith and Richard Barid of Smith Barid LLC. They both live in the Savannah area and are licensed to practice law in the state of Georgia, where they focus their practice exclusively in elder law and estate planning. Hello, gentlemen, and welcome to the show today.
Hi, Mary. It's great to be here.
Yes, it is.
There are so many areas of law you could have chosen to practice in, so why did you choose elder law and estate planning?
Mike and I first met in law school at UGA, and after we graduated and passed the Georgia bar, we worked at different firms for about 10 years, but neither of us was truly happy, and more importantly, we felt a calling to help other people.
That's right, and for us, the best way to help people is helping them prevent problems before they happen, which is why we create effective estate plans and long-term care plans to protect our clients and their families.
Richard, we talk about the various aspects of estate planning every week, but I often hear people discuss it as something they need to take care of when they get older. Exactly when should a person create an estate plan?
Well, technically, when they turn 18, they should have at least a power of attorney and a healthcare directive, because at their age, their parent or guardian can't make legal or even medical decisions for them.
But isn't it unlikely that an 18-year-old or even a person in their 20s is going to need those type of documents?
The youngest person I've worked with who had a medical emergency requiring those documents was 21 years old. It was a very serious accident, and he was in a rehab facility. It was a terrible situation. His parents were so upset, they would have been thankful to have had a power of attorney and a health care directive in place before the accident.
That isn't something I'd want to think about if my loved one was that seriously ill or injured.
Exactly. Regardless of age, if you had a car accident or a stroke or some other serious injury or illness, think of the stress on your family. They'll drop everything to be with you. They might have their own family members dependent on them or a job. Now, on top of all that worry and stress, they've got to figure out how to get the legal authority to pay your bills, deal with your insurance company, basically to protect your health and your finances.
I certainly wouldn't want that stress on top of everything else. So, Mike, if a loved one has a car accident or something else that happens to result in their incapacity for a period of time, we'd need your office to create a power of attorney for them at that time?
If they have the capacity to understand what they're signing or having someone sign for them, we can create the documents at the time of the emergency, but that's not the ideal way to do it.
How does that work? Do you have to go to them?
Yeah, so one of us has to go to the facility, explain the documents, make sure the person understands the documents and agrees, and then we have to make sure that they're not being pressured to sign the documents.
And is it more expensive in an urgent situation than if they had planned ahead?
Certainly. It's more expensive because we have to work fast. We have to set aside other things that we're working on, and it usually means an attorney from our office has to go to that person. We also often have to bring witnesses and a notary with us, so it's stressful, and because it's urgent, there's added expense. It's really not the ideal situation.
If you go to the hospital or rehab facility for wherever that person is, and you find that they just really don't have the sufficient capacity to understand what they're signing, then what?
Well, sadly, we'd need to work with the family to go through a court process called conservatorship.
What is conservatorship?
The family would hire us to ask the court to appoint someone to manage the incapacitated person's finances. If that person didn't have a health care directive appointing a health care agent, we'd also request a guardianship to have a person appointed to make health and safety decisions.
When you say a court process, that sounds like this isn't just going to happen overnight. It's going to take some time, isn't it?
Yeah, that's right. We need to create a court document called a petition. So it isn't something we can just whip up the same day. First, we have to get financial information from the family and sometimes a doctor's opinion about the person's condition. Then we need to give specific notice to family members and others who are interested people under the law.
An interested person? Who's considered an interested person?
So the person who is having the capacity issue, as well as their family members and sometimes close friends.
What do you mean by give notice?
Well, the family members or close friends who are considered interested persons get notice by certified mail with a return receipt, but the sheriff's office actually serves notice on the person with the capacity issue.
The sheriff? But isn't it just usually a spouse or somebody close to the person who is offering to step in as a conservator? That seems like a lot of work, especially if the family isn't disputing Who should be the conservator?
I agree. Remember, all of this can easily be avoided if the person had just signed a durable power of attorney while they still had capacity.
But if we procrastinate, we're potentially putting an unnecessary burden on our loved ones to go through this process if we lose our capacity for a period of time in the future.
That's right, and it doesn't mean you're old or having issues to have a power of attorney. It's just the grown-up thing to do.
I can't see why every adult would want to have this in place in advance as opposed to a conservatorship. And how long does this whole process take?
Well, realistically, an extremely smooth conservatorship proceeding would take at least a month from the filing of the petition. And in most cases, it's much longer than that.
At least a month. That's a long time, and I'm sure all of that work is more expensive than just having a power of attorney executed while we're healthy.
Yes, and during that waiting period, no one can take care of the person's financial affairs or decisions, meaning even the family cannot access bank accounts or other assets until a conservator is appointed by the court.
Now, we know as adults we should all execute a durable power of attorney, but for those who still don't, it sounds like your office helps families obtain a conservatorship if something happens to their loved one's capacity?
Usually, but just so our viewers know, our office doesn't accept contested conservatorships. So if family members are disputing who ought to be the conservator, they should hire a firm that handles litigation.
And of course, fighting would be extremely stressful and take even more time and money. So planning ahead is always the smart move. So thinking about time and money, I recently saw some shocking numbers regarding the high cost of nursing home care in Georgia.
Yes, the average cost of a nursing home in Georgia is now at least $6,300, and that's for a semi-private room.
So over $6,300 per month, that would be over $75,000 per year. I would think that most Georgians can't afford that expense for very long.
You're right. In 2017, the Government Accountability Office determined that the average American between 55 and 64 years old only has about $107,000 of retirement savings. So it wouldn't even take an average 64-year-old a year and a half to spend their entire life savings.
Wow, that's shocking to think about. I mean, what advice do you have for us then?
Well, people need to understand the facts and their options. First, many people mistakenly think Medicare will pay for nursing home care, but it only pays for up to the first 100 days.
So that's only about 3 months. Is the 100 days a sure thing?
No, it's not a sure thing. It's not always 100 days. There are Medicare guidelines to determine how many of the potential 100 days a person gets.
Okay, so after Medicare coverage ends, then how do we pay?
Then people are personally responsible to pay for that care.
Do long-term care insurance products help?
Yes, if you purchase coverage while you're still young enough and healthy enough to qualify. But once you're very ill or advanced in age, you probably won't qualify for that type of insurance.
What if I just don't have the money to pay that high cost of care? What happens to me?
Well, if you have resources, you have to spend those resources until you no longer need skilled care or until you're broke. Once you're broke and still need a high level of care, you can apply for Medicaid.
Okay, so for the average American who has $107,000 in retirement savings, living in Georgia and needing skilled care in a nursing home, they may qualify for Medicare coverage for up to 100 days. But then they would pay at least $6,300 or more per month for care. Then within about a year and a half, they'll probably be broke and need to apply for Medicaid?
Yes, that's a common scenario.
Well, let's first talk about what it means to be broke. What assets count when a person applies for Medicaid?
An unmarried person can keep a home, a vehicle, insurance with a death benefit up to $10,000 or a prepaid funeral plan, a burial plot, and up to $2,000 of other assets.
Just $2,000? Well, at least they get to keep their home.
Yes, but when a person applies to Medicaid, they have to agree to something called estate recovery.
What is estate recovery?
It's a collection process that occurs after a person passes away, where the state can put a lien on the home to recover some of what they've paid for the Medicaid recipient's care.
Okay, I've heard about a couple of deeds that prevent that from happening. I believe one of them was a joint tenancy deed. It transfers the home automatically when you die to avoid probate, so it avoids estate recovery too?
Well, a joint tenancy deed is nice in that it avoids probate and sometimes could avoid estate recovery, but it's a lot more complicated than that.
I talk to you enough each week not to be surprised by that.
The other type of deed you've probably heard of is a life estate deed. It gifts your home to somebody else and you retain a lifetime right to live there, so you're gifting a portion of your home to somebody else.
But I could still sell it or do whatever I want with it, right? I mean, after all, it's my home.
No, you would now co-own your home with whomever you gave the remainder to, so you actually can't do whatever you want with it. For example, if you have 3 sons and you gave the remainder to them, you'd have to get them to sign off on anything you wanted to do with the house.
I trust my sons, but what if they divorced or had problems of their own?
Their problems then turn into your problems. Another issue that it can cause is a period of ineligibility for Medicaid because Medicaid has gifting rules.
Because if I'm applying for Medicaid, I can't just gift my assets away and then say I'm broke and I need care?
That's right. Medicaid asks about the gifts you've made for the 5 years prior to the Medicaid application and penalizes those gifts, so you have to plan ahead.
You mean I'd have to give all those assets away 5 years before I thought I needed to be in a nursing home?
Yes.
That sounds a lot more complicated than I thought. I've also heard about percentage deeds. Are they a better solution?
Not really. Again, there's still a gift for Medicaid purposes, and you're still giving someone a portion of the ownership of your home.
I guess with anything, if it sounds too good to be true, it probably isn't.
Yeah, maybe so, but the good news is that those aren't the only options to avoid probate and a potential Medicaid lien.
That's great news. Do these options just protect our home, or can they protect other assets as well?
Well, for example, an irrevocable trust can protect your home, other real estate, and even your investment. But 2 things to keep in mind. First, you almost always get the best outcome by planning ahead. And second, beware of cookie-cutter solutions.
That's exactly right. The best option is based on your circumstances and goals, and that's why we're happy to help you determine your best options during our estate planning consultations.
The irrevocable trust is an important piece of the estate planning puzzle. When Elder Care Answers returns, we'll talk more about irrevocable trusts and gifting. Stay with us.
Welcome home to Shepherd Living at Savannah Quarters. Our chefs are serving up fresh, locally sourced goodness from southern farms and shores, paired with inspiration from around the globe. Share a meal with us today, or better yet, make Shepherd your home and call our kitchen your kitchen. Discover the joy of stress-free wellness resort-style living. Give us a call at 844-8-POOLA or stop by anytime at 101 Shepherd Way on the corner of Pooler Parkway and East Haven Boulevard. We'd love to meet you.
Right arm, right leg.
Left leg, left arm.
Both legs above the knee.
Both legs, part of my left hand.
Lost both my legs in Iraq.
These 9/11 veterans are just a few of the heroes we serve at Homes for Our Troops. For nearly 2,000 severely injured veterans, everyday life has become filled with barriers. So we build specially adapted homes with features like wheelchair access, roll-in showers, and pull-down cabinets that allow them to function independently and focus on their recovery and family. This life-changing gift of freedom is provided mortgage-free to these veterans, thanks to our donors and supporters. But we need you to join us too in completing this important mission. Please visit hfotusa.org and help build homes and rebuild lives.
It takes less than 1 minute to find out if you may have prediabetes, and you can do it here. So what are you waiting for? Just go to the site.
Welcome back to Elder Care Answers, the show that explains how to prepare for your elder care and estate planning journey. Now, Mike, before the break, you mentioned the irrevocable trust. That's what you call your box, right?
Yes, in our office, we refer to the irrevocable trust as a box. But of course, we thoroughly explain that it's a trust, but irrevocable trust is quite a mouthful.
Plus, it's easier to visualize how our box works. It's similar to a safe where we put our valuables, then we lock it up for safekeeping.
Exactly. There are many types of irrevocable trust for a variety of goals, but when we discuss our irrevocable trust that we refer to as our box, it's usually to protect assets from the high cost of long-term care.
So how does a box help?
Unlike children, boxes don't get divorced, addicted to drugs, or pass away unexpectedly. They just sit there and hold your valuable assets.
I like that. But what else do we need to know about the box?
Well, every gift, including a gift to a box, has a 5-year look back, meaning that we can't just give everything away today and immediately qualify for Medicaid. Gifts in 5 years before Medicaid application could cause a period of ineligibility.
So let's say a person gave away $67,000 within the past 5 years and then needed to apply for Medicaid now. What would happen?
Okay, if the gift was to a person, hopefully they still had that money and were able and willing to return it. If so, then we're fine, no penalty period.
I bet that rarely happens, though.
It is rare that individuals still have the money and will return it. So in our example, with a $67,000 gift, under current rules, there would be about a 10-month period of ineligibility for Medicaid, meaning that once that person was broke, she'd have to private pay for 10 months until the penalty was over.
But if she's broke and she's on a penalty for 10 months, how can she pay the nursing home over $6,000 for 10 months?
Good question. That's a big problem, right?
If she had gifted that same money to a box, the outcome would probably be different because the money is still in the box, so we can fix the problem and get her Medicaid eligible.
So, for simplicity's sake, sometimes we're referring to our irrevocable trust as a box, but aren't all irrevocable trusts basically the same?
No, and we get that question a lot. There are different types of irrevocable trusts for different purposes. For example, just a few decades ago, irrevocable trusts were often used to avoid estate taxes, sometimes called death taxes. Irrevocable trusts can still be used to avoid the death tax, but due to the changes in the law, that tax only affects the wealthiest of the wealthiest Americans, which is currently projected to be less than 1% of us.
Less than 1% of Americans are projected to pay the death tax? Then why would we want an irrevocable trust?
Because of the high cost of long-term care. Right now, most of our clients who create an irrevocable trust are creating it to protect certain assets in case they need expensive care.
I understand the cost of care is scary, but what advantage does gifting to an irrevocable trust have over gifting to people like our family members?
Well, bad things happen to good people every day, so gifting to a person is inherently risky, but trusts have less risk associated with them.
Well, that makes sense, but what about taxes?
Well, the tax impact usually works out well. Usually when we draft the trust so that the people creating the trust still pay the taxes on the income from those assets, but just like they did before the trust. If they put their home in the trust, they can even still reserve the right to live in it. And if they're a senior citizen, they can still get all of the tax benefits of being a senior citizen who owns the home, the homestead exemption.
But who owns those assets?
Trust assets are owned by the trust, not by the person creating the trust or even the trustee, who is the person managing the trust.
And that's good because, like you guys always say, bad things can happen to good people, right?
That's right. If the trustee owned the assets, you'd have the risk of all the bad things that can happen to a trustee. But the irrevocable trusts don't get sick or injured, they don't have car accidents, divorces, or develop addictions. They just hold your assets.
That sounds perfect. The trustee doesn't own the trust assets, but the trustee controls the trust. That sounds similar to like a manager of a store who works there but doesn't own the store.
Yes, the trustee controls the irrevocable trust, but the trustee doesn't expose the trust assets to any of the bad things that could happen to the trustee.
Do your clients ever struggle with giving control of the trust to their trustee?
Well, most don't because they have a trusted family member who can serve as the trustee.
Who is the trustee? Does it have to be a family member?
The person creating the trust chooses the trustee, and it can be whomever they want. Most of our clients choose a trusted family member like a child, but it could be anybody that they trust, including a professional such as a CPA or a bank.
Let's discuss what's probably a common scenario. Mom gifts her house to her irrevocable trust and makes her son the trustee. Then she wants to move to a smaller home, so her son, the trustee, signs the deed and the proceeds remain in the trust. Then the son can use the trust assets to purchase her a new home in the name of her irrevocable trust. Is that right?
Yeah, so the plan can change as mom's needs change without affecting her 5-year look-back period.
Well, that all sounds perfect. But are there any disadvantages? When doesn't it work?
Yes, if mom isn't comfortable with the trustee having that control, then she shouldn't create an irrevocable trust because we don't want her to be worried or upset. She needs to have a trustworthy person serve as trustee, and that person has to follow the trust rules.
But if she doesn't create the irrevocable trust, her home or whatever assets she would have funded into the trust are exposed if she goes into the nursing home and needs to apply for Medicaid.
Right, that's the trade-off. Keeping control of the assets and exposing them to the high cost of nursing home care versus keeping less control and getting asset protection. Most of our clients who have a trusted family member are pretty comfortable with the irrevocable trust.
It sounds like if a viewer is considering gifting or is concerned about protecting assets from potential long-term care crisis, they should schedule a consultation to see exactly how the irrevocable trust would work for them. So now we understand how an irrevocable trust or safe box works. But how does a person who has disabilities protect their assets in an estate plan? Mike and Richard will answer that question and more when Elder Care Answers returns.
Welcome home to Shepherd Living at Savannah Quarters Memory Care Community. You've spent a lifetime together. Why should that change now? Maintain your independence and lifestyle while still remaining there for your loved one with Alzheimer's. Secure all-inclusive care within our Savannah Quarters Senior Living Resort community. Give us a call at 844-8-POOLA or stop by anytime at 101 Shepherd Way, next door to our independent and assisted living community. We'd love to meet you.
So there you are, shuffling through a stack of resumes and you come to mine. This is it, first impression, my way in. But can my resume show you how I truly stand out? Like that I was studying, going to night school while working 2 jobs just to help my parents pay for groceries. Or being the first one to always step up. No, that's something you just can't put on paper. Look beyond the resume and discover new ways to develop great talent that is dedicated, hardworking, and determined like me.
Welcome back to Elder Care Answers. We've been talking about how irrevocable trusts can protect your assets in an estate plan. But what about trusts for people with disabilities? Mike, I understand there is a special trust for a person who has disabilities to help protect their money. Can you tell us more about that?
Absolutely. A person who's born with or develops disabilities during their lifetime is more likely to have higher medical costs than someone who doesn't.
But there are government benefits that serve as safety nets for those persons to make sure that they always have some level of income and medical care, right?
Yes, but these programs look at the person's assets and income to determine if they qualify for benefits, and if they do qualify, at what level.
If a person with a disability, say autism or Down syndrome, qualifies for SSI and maybe even Medicaid, and they inherit money from somebody such as a grandparent, is that okay?
Well, it's very likely that the inheritance will cause her to lose her benefits for at least a period of time.
But she might not need them anymore if she inherited that money.
Maybe, but if she doesn't have her Social Security income or Medicaid for health care, she's probably going to burn through that inheritance pretty quickly. Then she'll need to reapply for benefits, so the inheritance might not be as much help as Grandma had hoped.
Could she just disinherit her and maybe give her inheritance to a family member to use for her benefit?
Yes, but that puts quite a burden on the family member to do that. And remember, bad things can happen to good people.
After talking to you each week, I understand that a myriad of things could happen to disturb that plan. That family member may not use it properly, or they might even pass away themselves. So what's a better solution?
A special needs trust can hold the inheritance so that it doesn't disqualify her for benefits, and a trustee can manage the trust for her.
If the person with a disability has any type of windfall that could disqualify her from these benefits, whether it's an inheritance or a settlement from an accident or any other source, we could set up a special needs trust to protect her benefits?
Yes.
That sounds great. I mean, can other people put money into it too?
Yes, there are slightly different rules for special needs trusts created by another person versus one created by the person with the disability for themselves.
So it's usually better if a loved one uses the money set up the trust for the beneficiary rather than giving the money directly to the beneficiary to set up for herself.
But even if they mistakenly gave money directly to the person with disabilities, or if that person gets a settlement or something like that, it isn't too late to create the trust?
That's right.
All of this talk about managing assets has me thinking about business owners. Do they have unique estate planning concerns too?
Yes. When we work with business owners, we usually find that they aren't structured properly and they don't have appropriate business succession planning.
Exactly. Mary, did you know that according to the Family Business Institute that only about 30% of family-owned businesses survive into the second generation, and only 12% are still viable into the third generation?
But business owners work so hard to build their businesses. It's a shame to hear those kind of statistics.
It isn't that they're lazy, but over time the business changes, laws change, and even family dynamics change. While the owner's focusing on building and growing their business, often they have an idea of what they want to happen when they retire or pass away, but it isn't enough for it to happen.
I'm sure it's difficult to figure out how to handle those types of decisions, so they probably get pushed to the back burner.
Well, that's where we come in. We use our experience to simplify difficult decisions while helping the owner to achieve their goals for the business.
Well, that makes sense. It sounds like dovetailing your business planning with your estate planning should be a really important goal for business owners. And talking about our busy business owners makes me think even non-business owners are busy. How do we know we're making the best decisions?
That's right. There are a lot of little things that can change the advice we give a person, which is why our office tends to ask a lot of questions when we meet with a new client. We don't want to miss an important fact about them or their family and have some unintended results.
How do you know which issues need to be considered?
Experience and education. We've worked with over 1,000 clients in the past decade. Almost every single continuing education course we've taken during that time has been about these types of issues.
Yeah, it isn't as easy as downloading a will from the internet. We see those kinds of documents every day, and honestly, they keep us in business. Because we get hired to fix the problems created by people who didn't realize they needed our experience.
And you don't practice in any other area of law?
No, that's right. And our office does not litigate contested cases either. We create and update estate plans, qualify clients for nursing home, Medicaid, and VA benefits, obtain conservatorships and guardianships, probate estates, and we settle trusts.
And you can help small business owners too?
Yes, we work with many small business owners to dovetail their business planning with their estate planning.
Where do we start?
Whether you need an estate plan or you have an estate plan that needs to be reviewed, it all starts with a consultation.
Is there a fee for that consultation?
Yes, we do charge for the consultation, but what our clients really appreciate about our office is that the initial consultation fee is applied to your fee for your estate plan.
So there you have it. Start preparing your future by contacting Mike and Richard at 912-250-5181. You can also visit their website, smithbarid.com/info, and follow them on Facebook, LinkedIn, Pinterest, and Twitter. You can request an appointment, read their blog, and find other resources to help with your estate plan, and there's always new information being posted. So thank you for joining us today, and we'll see you next time on Elder Care Answers.
Welcome home to Shepherd Living at Savannah Quarters. Shepherd Living is unlike anything else. From our greenhouses and farm fresh restaurant to our fully outfitted spa and wellness center, it's all-inclusive wellness resort style living. After all, what good is living longer if you are not living well? Give us a call at 844-8-POOLA or stop by anytime, 101 Shepherd Way at the corner of Pooler Parkway and East Haven Boulevard. We'd love to meet you.